Welcome back, everyone. Sean Stevens here again with Metroplex Mortgage Services, bringing you another divorce lending video quick tip. What refinance options are available for divorcing homeowners? Understanding the divorce refinance process is critical towards maximizing the available equity, maintaining affordability, and complying with the terms of your divorce. In today's short video, I will discuss available divorce refinance options and provide an introduction to the process. Now, before we get started, don't forget to take advantage and download our Divorce Lending Blueprint for Success with the link below. This free guide is to help walk you through the divorce refinance process step by step. It is a great educational tool for both homeowners and attorneys alike. As a starting point, most refinance scenarios will fall under one of two categories, either a rate and term or cash out. A rate and term refinance replaces the existing mortgage with a new loan, typically to improve the rate, adjust the term, or remove a co-borrower, such as a departing spouse. However, it does not permit any cash out to be taken at closing, which generally makes it more favorable in terms of interest rate and loan to value flexibility. This matters for attorneys because it can be a cost-effective solution when the remaining spouse needs to refinance quickly and remove the ex-spouse from the mortgage without accessing equity. On the other hand, a cash-out refinance allows the homeowner to tap into their home equity, refinancing for more than the current loan balance and receiving the difference in cash. This is often used to pay for settlement obligations, pay off joint debts, and also fund relocation or legal expenses. Due to the additional cash out being received, this option is viewed as higher risk by lenders, which often means higher interest rates and lower maximum loan to value ratios. This matters for attorneys because although a cash out refi may be able to accomplish the end goal, this solution can be problematic if equity is tight or the client cannot qualify at the new rate or LTV. Another important question that comes up is how does loan to value limits impact divorce refinancing? A loan to value, also known as LTV, is a key factor in determining which refinance options are feasible. It's calculated by dividing the loan amount by the appraised property value. Rate and term refinances may allow LTVs up to 95% or higher depending on the loan program, while cash out refinances are usually capped at 80% LTV. VA loans are an exception and can allow cash out refinancing all the way up to 100% LTV. For example, if you have a loan amount of $500,000 and the home was appraised for $625,000, your loan to value would be 80%. Please note that a poorly timed or structured marital settlement agreement could leave your client ineligible to refinance or worse, force a property sale. Knowing LTV limits help you draft agreements that reflect mortgage realities. Now you may ask, is there a way to access equity and get more favorable loan terms? Yes, and it's one of the most misunderstood options in divorce mortgage lending, the equity buyout refinance. An equity buyout allows one spouse to refinance the mortgage into their name and access equity to buy out the other spouse without triggering the terms associated with a cash out refinance. This requires specific documentation and structuring, but when done properly, it combines the affordability of a rate and term refinance with the functionality of a cash out. This matters because the equity buyout strategy is often the most efficient way to structure a refinance while preserving equity and keeping the marital home. Strategic mortgage planning is a must in divorce because understanding refinance options is just a start. The real advantage comes from proactive coordination between attorneys and lending professionals to ensure that financing is feasible before agreements are finalized, settlement terms align with actual loan program guidelines, and clients aren't forced into higher rates or failed closings due to overlooked loan requirements. As you've seen in today's video, choosing the right divorce refinance option is critical to structuring a successful settlement, but the decisions don't stop there. Our divorce lending practice group specializes in aligning mortgage financing with divorce settlements, helping attorneys and their clients avoid common financing pitfalls, maximize available equity, navigate unique loan to value and eligibility requirements, ensure settlement compliance, and preserve home ownership options. Whether you're structuring a buyout, planning for equity division, or addressing tight timelines, we can help provide clarity and guidance at every stage of the process. If you need a case consultation or have a question, just call, text, or email because our team is ready to assist. And most of all, I want to thank our family law partners for the continued referrals and the trust you place in our divorce lending practice group. We're proud to support your clients through the complex real property issues that arise during divorce. As a scheduling note, we are currently coordinating in-office and virtual presentations for family law firms. If you'd like to take advantage of this personalized training, we'd be happy to tailor a session for your team, covering key topics such as equity buyouts, refinance timing, and how to avoid mortgage-related pitfalls when drafting marital settlement agreements. Just contact my office today for flexible options so we can reserve your preferred date. Thank you again for forwarding and sharing today's post with any attorneys, clients, family, or friends who may be in need of our divorce mortgage expertise.